This is David Olshan of Nevada Legal Services. This is another in our series of substantive law videos. This video covers reaffirmation agreements. So the first thing you need to know is what is secured property. You're going to include secured debts in Schedule D of your bankruptcy petition. It's basically a lien on your property, usually your home or your car. It can include a vacuum that you buy and the creditor has a lien on it. Furniture, sometimes rent-to-own furniture has liens on it. A rental lease, usually not. Pawned items, usually not. But those are more nuanced questions. Basically, the lien attaches to the property, the car or the home, and the right of the creditor to repossess it if you default that secured debt. So we should talk about the consequences of reaffirming a debt. This reaffirmation agreement takes the debt out of the bankruptcy and you will still owe the reaffirmed debt, and it's as if you did not file for that specific debt. Many creditors do take advantage of the reaffirmation agreement, so that's why we are going through this now. Be careful. There are protections. If you go to bankruptcy court, you will see an attorney in the courtroom explaining to you the consequences of a reaffirmation agreement. A reaffirmation agreement, you should read it carefully. It contains all the disclosures, the terms of the reaffirmed debt. The judge must approve it, of course, if you're not represented by an attorney. But if you don't reaffirm a secured debt, usually the automatic stay ends. So, if you do want to reaffirm a debt, you must state your intention on Form 108 in your bankruptcy petition. You have 30 days from the filing date or the meeting of the creditors, whichever is earlier. You must state your intention and then notify the creditor. You can either retain or surrender. You can redeem, but not for real property. And of course, we're talking about reaffirmation, or you can do what's known as other, and we will talk about that. So within 30 days after the first meeting of the creditors, you must perform your stated intention. So if you're going to sign a reaffirmation agreement, you must file it with the court within 30 days after your meeting of the creditors. If you are current with your car or house payment, you are going to put pay as agreed as your intention, and you do not have to sign a reaffirmation agreement. These items must be exempt, meaning the equity in your car must be $15,000 or less, and the equity in your house must be $605,000 or less. But if the asset is exempt and you're current with your car or house payment, you do not have to sign a reaffirmation agreement. The creditor cannot repossess under Nevada law. You must default in payment under Nevada law for the creditor of a car to repossess a car. For a house, you can ride through. If you're paying and you're current, you don't have to sign a reaffirmation agreement. If you are not current with your car or house payment, you can surrender, you can reaffirm. If you don't reaffirm, then there's a problem. You're going to have to give up the car and the automatic stay ends because you will be in default. If you're not represented, the reaffirmation agreement must be approved by the court. You can try to negotiate better terms. You would contact your creditor. But even if you and your creditor agree to the reaffirmation agreement, the judge may deny it. The standard is the best interest of the debtor, and if you can't afford it or the collateral, the car is worth nothing, there's a possibility the judge may deny it. Standards of approval for a reaffirmation agreement. Why did you sign it? If a creditor threatened to revoke the discharge or puts undue pressure on you, that's a reason to deny approval. Can you afford it? Is the property worth what you're paying for it? Is the loan even secured? Sometimes second mortgages, there's no equity in the house, so you don't have to reaffirm those debts. Why would you reaffirm a vacuum when you're paying 3 or 4 times more than the price of a regular vacuum? So those are some of the things the court is going to look at. And of course, you must file this reaffirmation agreement and get approval from the court before your case is closed. So there is a time limit, and if you have questions, contact us at Nevada Legal Services. We can give you advice on how to proceed with a reaffirmation agreement or tell you it's just not a good deal. We are Nevada Legal Services. In Southern Nevada, call 866-432-0404. In Reno or Northern Nevada, 800-323-8666. We provide free legal assistance. We can advise you on what to do in a bankruptcy or what to do with regard specifically to a reaffirmation agreement. Just give us a call or visit our website and do that as soon as possible, because there are specific time limits for the reaffirmation agreement.